Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Thank you. Good afternoon, Mr. Singh. Can we just finish off the topic which we were on, which was the purposes of prosecution and whether it included the protection of the post office brand? Can we look, please, at POL 00148137? This is an email exchange between you and Gavin Matthews in the run-up to a conference to be held with Mr. Altman, KC, on the 25th of April 2014. Understand?
Yes.
And at the foot of the page, Mr. Matthews says, here's the draft agenda. And it's all about the post office's prosecution policy. Okay?
Yes. Yes.
And if we go up to the top of the page, please, you make a comment on it. And you say, read a business improvement program, etc. Whilst there's a suggestion that other avenues should always be considered and rejected before a criminal investigation is commenced, there will always be cases where it's immediately apparent that a criminal investigation should be commenced with a view to prosecution to protect the post office brand and reputation and in the interests of the business, etc. Was it the case that some prosecutions were to be commenced in order to protect the post office brand and reputation?
I suppose in that sense it is a business. I don't recollect what this is, but certainly it's a consideration in any business.
Was it a message that you were keen to emphasise?
Not me personally, no.
Can we go on, please, to POL 00148242? This is after the conference with Mr. Altman on the 25th of April 2014. And it's an email from you to Ms. van den Boogaard. And you say, during the recent Altman meeting, when the attached was mentioned, you indicated that there would be cases where immediate intervention and suspension would be justified. And then I think an obvious starting point, for example, are cases of shortages of between £20,000 and £30,000. And then you say there will be cases in which it will be clear from the outset that the post office will need to conduct a criminal investigation with a view to potential prosecution to protect the post office brand and reputation and for business purposes. So you're making the same point again, aren't you?
Yes. I think it's a discussion paper. I don't think it's any more than that. I think you've got various people around the table, and I'm just highlighting various aspects of it. You know, that's all. I mean, I don't know. You've got other people putting their side of the argument. I'm putting the other things to be balanced with a view to coming to a solution, I suppose.
Was it your aim to emphasise the prioritisation of the post office's reputational and business interests?
No, maybe not.
Why do we see this appearing twice in very similar phrases, both before and after the meeting with Mr. Altman?
I think it's probably discussion with my line manager, I'm just, because I think I'm not there just for myself. It's sort of emphases on various aspects I've been advised on to get advice on and relay back. I don't think it's a personal view.
Okay, thank you. That can come down. Can I turn to my fourth topic, please, which is Second Sight, their appointment, the announcement of their appointment, and the need to give an account, tell a story about their appointment. Did you think it was important to create a message, a story, that could be told or broadcast in response to the appointment of second sight?
And not personally, no.
Can we look, please, at POL 0014 3374? And if we look at page 2, please. And this is an email from you of the 11th of July 2012. So when Second Sight's proposed appointment was an issue to Susan Crichton, Hugh Flemington and Olwyn Lyons. And you say, I need to address and to prepare counter-arguments to issues which are being raised and will be raised by defence lawyers after the Post Office announced that Second Sight will conduct a review of the Horizon system, even though the Post Office says Horizon is robust, when challenged has always successfully defended the system in high-profile criminal trials in Crown courts. Defence lawyers will say, why appoint a forensic auditor to examine the system? Can you please help me with the following in order for me to put flesh on the bones? The reasons for appointment of a forensic auditor to examine the system, what is Second Sight's remit, what they will look at or ask to review, or what is being undertaken or not. Are they reviewing few, several, or some isolated cases only? Are they really looking at examining the Horizon system, or in reality looking or examining certain branch accounting procedures and processes? Anything that you may consider useful. It may be considered useful at this stage to have a press release to reconfirm integrity and robustness of the system, but in addition including the remit of Second Sight. Sorry for the 20 questions. So you know that defence lawyers may ask questions in extant criminal proceedings along the lines that you set out, and you were seeking instructions, correct?
Yes.
At this time, Second Sight, the forensic accountants, their appointment was contemplated, and you were considering what effect there might be on ongoing proceedings, correct?
No, I wasn't personally. I didn't even know they were on board. I think it's something that Sir Cartwright King, who are prosecuting, getting letters from the defence.
Whether you were dealing with this personally for cases in which you were a prosecutor, or whether Cartwright King were prosecuting those cases, you were seeking instructions either on behalf of yourself or for Cartwright King in order to be able to meet any defence challenges, correct?
I don't think I wouldn't put it like that. It's something referred to me, I think, by Cartwright King saying, what we got to respond to the defence. We need to know the reason why, or remit, or why it's Second Sight engaged. They needed a response, I think, to be able to respond to whatever the defence, respond to the request from the defence, saying, well, why Second Sight? What are they reviewing? What are they there to do?
Yeah, so asking a series of not unreasonable questions about what's this all about.
What's it all about, yes.
Yeah. Can we see what happened as a result? Poll 305 8155. And go to page 3, please. Can you see in the middle of the page, we've got it up now, the text of an email sent by you to Hugh Flemington?
Yes.
Yes? The one beginning after a number of meetings, yes?
Yes, yes.
Is this the proposed draft of what was to be said?
I don't recall, to be honest. I don't can't remember where we are. I know it took a long while.
We'd seen before that you've been asking for some instructions about what's this Second Sight review all about, what work is it undertaking. We need to put out a message, essentially, when asked questions by the defence in criminal proceedings. It seems there's been a meeting, if you look at the top of the page. This is the story text which Jarnail put together following our meeting last week.
Any comment, please, community,
Yeah.
please? Yes.
So if we read it, after a number of meetings between Post Office management and MPs in relation to the court cases, it was agreed that Post Office would undertake a review of the cases which had been raised by the members' constituents. In order to provide assurance to the interested parties, Post Office management proposed the use of independent auditors' second sight. The review is to be undertaken will be specifically restricted to the cases raised by the MPs, as well as reviewing the accounting procedures, processes and reconciliations. Before formal instructions are given to the independent auditors, agreements will be sought from all interested parties, namely MPs and JFSA. The sub-postmasters have requested a forensic accountant of their choice to be appointed to oversee the cases being reviewed by second sight. All of the above is accepted based on the terms of the review being carried out, but it must be stressed this is not an acknowledgement by Post Office that there's an issue with Horizon. The Horizon system is working properly, robust, and is being used up and down the country. When the system has been challenged in criminal courts, it has been successfully defended. So was this your first attempt at a draft of what to say in response to questions that were raised as to why Second Sight had been appointed?
I know there was... it was difficult to formulate it because I didn't really have much information on it. I know I had to go to Rob Wilson, at the head of criminal law, because I think he'd been dealing with this.
Mr. Singh, just
sorry.
putting to one side for the moment who you went to in order to draft it.
That was the first draft, yes.
This is the first draft?
Yeah.
Okay, thank you. And then if we go to page 2, please. And scroll down. And again. We can see that Olwyn Lyons, the company secretary, passes this to Simon Baker and others. Simon, can you go to Alana with this request for the, quote, story, as they are the experts? Then up the page, please. Stop there. Simon Baker sends it on to Alana. Please help us craft our message around the Second Sight review. We need to combat the assertion that the review is acknowledgement there's a problem with Horizon. Jarnail has drafted some words below. Do they strike the right tone? Then up the page, please. And then Ronan Kelleher, if we just scroll down, we can see who he is. The head of PR and media. Did you know Mr. Kelleher?
No.
But anyway, up the page. Simon, as this message will probably find its way into the media, we do need to get the message across from the start that we continue to have full confidence in the robustness of the Horizon system and then reinforce it. So I suggest the following tweaking to the proposed wording from Jarnail, and then it's set out. And I'm not going to go through a line-by-line comparison of the changes that have been made. Do you know why the head of PR and media at the Post Office was being involved in the creation of a story that would be given to or told to defence solicitors? No.
I didn't know they were going to be involved. I think it was the company secretary, Elvin Lyons, said they're the experts, referred it to them. I didn't even know. All I wanted was to get Hugh and Susan, the general counsel and head of legal, to help me with it and give me instructions and make a decision. But I didn't know. She referred it because she said they were the expert. That's the way they did things.
Okay, if we scroll up then, please. We'll see Simon Baker says that works, and then it's forwarded to... you're included on that chain, the that works chain, and you reply to Hugh, Susan and Olwyn, you've seen the final draft of, quote, our story. Can this now be released to our agents and counsel for consistent approach and submissions where there are challenges to the Horizon system? So did you understand the message, or our story as you called it, to be essentially the text that solicitor agents and counsel should use in submissions when an issue was raised as to the appointment of second sight in court?
I don't know that, but I can certainly say it was something that the Cartwright King wanted to know the reasons why, and all I've done is copied that into Susan and Hugh for a decision and assist me in doing it. And I think that what I've done is I managed to get a lot of information from Rob Wilson at the Royal Mail Group, who'd been knows the system, from the beginning, and he assisted and helped me with it, and Hugh and Susan took it forward.
But you would agree, your understanding of the purpose of this is for release to lawyers to ensure a consistent approach to submissions they might make?
It was going to go to Cartwright King. I don't know to what degree they would use it, but certainly they wanted a decision, and I've managed to pass it to head of legal and Susan to consider it in line with what they normally do, put it through the process, whatever they do, and they proved it, I think.
So does it come to this, a story that was drafted initially by you has been amended by the head of PR and media in the post office and is to be sent out to agents and counsel to ensure a consistent approach to the submissions they make?
I don't know whether that
I'm just reading various words on an email chain.
I appreciate.
And if you add them all together, that seems to be what they suggest.
I don't know. I don't recall exactly what happened after that, but that's the start of it, I think. Maybe it was. I don't know. I don't recall what happened after that. Was there not a lot more than that? I thought I know it took a long time to get it.
Let's go to what happened next then. Poll 0012 0723. And page 5, please. Can you see this is a witness statement from Mr. Bradshaw of the 20th of November 2012?
Yes.
And if we scroll down, can you see it says, after a number of meetings between Post Office management and members of Parliament, etc.?
Yeah.
Yes. And if we go over to the second page, it finishes off, when the system's been challenged in criminal courts, it's been successfully defended. That's the same wording as your story, as amended and improved by the head of PR and media in the Post Office.
Oh, well, I wouldn't go as my story. I mean, that's the Post Office story. It's what...
You called it our story, and you were part of the Post Office.
Well, that's what it's headed. But, I mean, I think you got the decision makers confirming...
Okay, I'll put it more neutrally then. It's part of some... it's based on text that you wrote, which have been amended by the head of media and PR in the Post Office, isn't it?
But that's the process they followed. And
it's ended up as a witness statement.
Well, it shouldn't have done.
Sorry?
It shouldn't have done.
Yes, and I'm going to ask you how it has happened.
I don't know. I don't know how it's happened, because all I've done is prepared it in line with my instructions from, the decision makers.
If we go back to the previous page, please. This is word for word the same as the draft of the head of PR and media.
Well, I can't answer that. He shouldn't have done. I don't know who put it in, because that's not the purpose for it.
Did you provide this to Mr. Bradshaw to put in a witness statement?
Absolutely not, no.
How did what started off as a message, a story for agents and counsels to work to when perhaps resisting application for a stay, resisting applications for adjournments or disclosure arguments get turned into a witness statement which contains a statutory declaration at the top?
I don't know. I don't recall, and I certainly didn't have any part to play. I've done, in line with the instructions and from the decision makers. I don't think I've ever not seen that before.
If we go back to page 1, please. And we scroll down, we can see that this example of Mr. Bradshaw's witness statement is disclosed as a notice of additional evidence in the case against Kim Wiley at Newcastle Crown Court. There are a number of others. I could point to many other witness statements where Mr. Bradshaw's made the same statement.
Yeah.
Can you help us how our story got turned into an account with a statutory declaration on it?
I can't help you because I prepared it as per instructions. I got Rob Wilson to look through it to make sure everything was okay. Then I referred it back to Hugh, Susan, and the company secretary. They took it up with the media. I've never come across, that's what they're going to do. But certainly that's not my intentions. That wasn't me doing it. I just did whatever I was instructed to do. And it certainly shouldn't have finished up in a witness statement.
You said earlier words to the effect that this is bad or it's poor or it shouldn't have happened. But why was it bad, poor, or shouldn't have happened?
Well, it's the witness statement is personal to whoever's making it. It should be factual, shouldn't it? It would be Stephen Bradshaw's recollection of his evidence.
And all of this went on without your knowledge, is that what you're telling us?
Yes, I don't recall. I mean, I don't recall that's where it ended up. No.
Okay, thank you. That can come down. Were you concerned about the disclosure of investigating officer reports because they might contain in them information that was of assistance to the defence?
No. I think what that was a view. Are you talking about mediation disclosure, or were you talking about generally?
Yes.
Mediation. I was not part of the mediation. I think it's an established group. They had their own remit, own way. They had their own decision maker. I was asked for a view, and I provided a view, saying that the officer's report was a working document, and it was updated periodically. So you need to look at it as a whole, rather than as a standalone document, because it wasn't. So I think it was something that I put forward because I was asked for a view, but I wasn't the decision maker, and it was just something that I provided for them to consider.
Can we look at an email discussion of this topic? Poll 00346092. And look at the second page, please. This is in the context of case MO 29, and you say, Andy, that's Andrew Parsons. I anticipate Chris, that's Chris Oyard, is the best person to make a decision on this point on behalf of the Post Office. Are allegations that Post Office has not properly investigated being made generally or in specific cases? One of the dangers of investigation officers' report being disclosed is that it will always be easy for the applicant to think of something not specifically referred to in the report and allege that Post Office investigation has not been sufficiently thorough or adequate. Of course, it's highly unlikely the investigation will have been deficient, but in the absence of a full set of papers, it may become impossible for the Post Office to rebut such new allegations. And then up, please, at foot of the page. Rod replies, having discussed it, the protocol for use of officers' reports by Project Sparrow investigators when responding to individual complaints is the report is not to be exhibited or expressly referred to in Post Office's formal response to a complaint. It can be used by the investigator to help them understand what's happening in a particular case. If the report is the only source document still available, investigator can repeat material from the report. Any challenge received about the source of a statement must be referred to Chris. So this is about what material investigators responding to or constructing investigation reports can refer to in the context of the mediation, okay?
Yes.
And if we go up to the top of the page, please. You reply to that. Having looked at the papers, I've no doubt this is the correct decision not to disclose officers' reports. In the case of Hamilton, that's Joe Hamilton, officers' reports had been, I don't know quite what you're saying here, but I think it means, if in the case of Joe Hamilton, had officers' reports been disclosed, this would have been extremely dangerous, or it would have been an extremely dangerous approach. Is that right?
Yes.
In the Joe Hamilton case, in the officer's report, the investigation officer said, quote, having analysed the Horizon printout and accounting documentation, I was unable to find any evidence of theft or cash-in-hand figures being deliberately inflated. In the absence of a file to demonstrate how the case developed, as it was further investigated, this would give the applicant and second side every opportunity to ask why, in fact, Joe Hamilton was prosecuted. In the absence of paperwork to deal with this would in turn cause Post Office difficulties. So by this time, you had read the investigation report into the allegations against Mrs. Hamilton, hadn't you?
No. This, I think there's different views on to disclose it, not to disclose it. I'm just basically highlighting to Chris and Jessica, my line manager, Jessica Medron, Hugh Flemington's left, and Chris has replaced Miss Crichton. All I'm doing is highlighting different points of view, and this is illustration as why you've got to weigh these things up and asking them to make a decision. That's all.
You'd read the report because you quote from it.
I don't know how that came about, but I don't recall exactly how that came about, but that wasn't the intention.
Okay, all right, I'll put it a different way. You knew that the investigation report contained the sentence, having analysed the Horizon printout and accounting documentation, I was unable to find any evidence of theft, didn't you?
No, that was not the case. This is basically...
Mr. Singh, it's in black and white or blue and red.
Yes, it may be, but I'm trying to illustrate a point, sometimes illustrating by example.
Yes, and you have plucked that example by either reading the report or somebody telling you what was in the report.
No, I think the intention basically here is to illustrate that, look, Chris, Jessica, you're the decision maker, you've got to weigh these things up. One saying to do it, one saying not. I'm not part of the mediation, I'm not a decision maker.
Mr. Singh, you're talking about different things now, whether you're part of the mediation and other issues.
Yeah.
All I'm doing is showing you your email, which has got a sentence in it, which is accurately quoted from the investigating officer's report. And all I'm saying is by this date, 9th of May 2014, you knew that investigating officer's report contained that sentence, didn't you?
I don't recall. I don't. I mean, that's just basically illustrating a point as helping Chris or Jessica to make a decision. There's no more than that.
Mr. Singh, you couldn't have written that unless you knew about it, could you?
No, I knew about it. But
that's all, Mr. I think that's all Mr. Beer was asking you to confirm.
But I haven't
that in order to write that, you either had to have read it yourself or been told verbatim what was included in the officer's report. That's all he was asking you.
Sorry, sir. Yes. I've not read the report, but I mean, it's there for a reason. Yes.
And you're giving that as a reason not to disclose investigating officers' reports, aren't you? That's the way you're deploying that.
I think what I'm saying is that you've got to have the paperwork to go with it. You can't just disclose it by itself. And it's at the end of the day Chris and Jessica to make the decision.
You're saying we can't disclose these reports. If we did, Joe Hamilton might ask, why was I prosecuted?
And not at all. No, I disagree. That's not the case.
What about the sentence, this would give the applicant every opportunity to ask why, in fact, Hamilton was prosecuted?
No, that wasn't the intention, no.
Why did you type those words?
I can't explain that now, but certainly it was getting a decision from Chris and Jessica to make, because there was a counter-argument for civil and criminal lawyers, I think.
That's a reason to give disclosure to Joe Hamilton, isn't it? Not a reason not to give disclosure to Joe Hamilton.
Well, I wasn't the decision maker. I was not part of the scheme.
If you just listen to the question, the fact that the investigating officer's report recorded that they were unable to find any evidence of theft is a reason to give disclosure to Mrs. Hamilton, not a reason not to give it to her.
Okay, I accept maybe my mistake. I shouldn't have gone in there, but that wasn't what this is about.
This is part of a cover-up.
No.
Isn't it?
There is no cover-up there on this email one-off. This is an email for them, decision-maker, to weigh things up. As far as the disclosure is concerned, I had no problem with any of it, because...
You say at the end, in the absence of proper paperwork, this report would cause post office difficulties.
No. That is to a complete file. What I'm saying is that you need to have a complete file to have a true picture of what's going on.
Well, I'm sorry to join in, so to speak, but I had forgotten momentarily how you begin this email, which is having looked at the papers. So does that not make clear, A, there was a file, and B, you had read it?
So it's not the full file. I think, as you see from the bottom of the chain of email, there's certain paperwork. I wasn't privy to the whole file. There's certain paperworks, and I've been brought in to refer it to the decision makers, Jessica and Chris, to make a decision.
Carry on, Mr. Beer.
Yeah, I'm not sure I can carry on any further with Mr. Singh on this point.
Fine.
Can we move forwards, please, to the Cartwright-King review process? And can we start, please, with paragraph 71 of your witness statement? Sorry, that document can come down, thank you. It's on page 26 of your witness statement.
Yes.
You say, I'm aware at this time, that's sort of mid-2013, that Simon Clark at Cartwright-King was advising Post Office on a number of matters, including disclosure and expert evidence issues. I agreed with Simon Clark's advice on this matter, ... I can't recall whether I received that advice, but if I did, I would have agreed it was an appropriate starting point based on what was known at the time around the Horizon issues. I noticed this was to be kept under review. I note that Simon Clark advised on the 19th of July 2013 in relation to miscarriages of justice. Again, I do not recall whether I received that advice, but the avoidance of doubt, I had no experience in relation to that issue and wouldn't have been in a position to agree or disagree with his advice. You say that you note that the advice suggested that the 1st of January 2010 be the start date for the review process, and you either agreed with it at the time or if you had read it, you would have agreed with it, correct?
I don't. It was what was suggested. Yeah.
Yeah, we're looking here at the issue of how far back the Cartwright King look should go. How far back in time should it go?
Yes.
And the start date of the 1st of January 2010 that was selected, yes?
Yes.
And you say that you either agreed with it at the time or you would have agreed it was an appropriate starting point based on what was known at that time around the Horizon issues, yes?
Yes.
So by this time, there was the second site interim report, this can come down, thank you, of the 8th of July 2013, which made reference to the receipts and payments mismatch bug, the suspense account bug, and the calendar square or Falkirk bug, yes?
Yes.
And I've suggested to you that you had become aware of the receipts and payments mismatch bug about 2.5 years earlier on the 8th of October 2010, and you've, I think, essentially denied that, yes?
Yes.
We know that you were aware of the suspense account bug by at least the 27th of July 2013. We looked at an email exchange earlier, and you agreed that, and that you were aware of the calendar square bug about 2.5 years earlier at the time of the Misra trial in October 2010, where it was actually raised in court, yes?
Yes.
And so you were aware that one of the bugs affected branches before the 1st of January 2010, correct? The calendar square bug.
Yeah, yes, yeah.
Do you agree that selecting the start date of the 1st of January 2010 would do nothing to address potentially unsafe convictions that had occurred before that date?
I wasn't part of the review. I wasn't the decision maker. It's something Sue's general counsel and the head of legal were getting advice from and progressing it. I wasn't part of the review because of the independency element of it. So I'm just the observer as to what date they decided to do. Wasn't part of that.
But do you agree as a matter of fact that, as a matter of logic, selecting the start date of the 1st of January 2010 would do nothing to address any potentially unsafe convictions that had occurred before that date?
But I wasn't the decision maker. I didn't make the decision that it's going to be 1st of January 2010 because I wasn't part of the review. And it was for the decision maker to make a decision on light of what advice they've been given.
Did you pipe up and say, hold on, I've got knowledge of a bug that occurred and could have afflicted sub-postmasters before the 1st of January 2010?
I didn't have any knowledge of it. I said to you that whatever I knew, they knew.
The calendar square, the Falkirk bug, from at least 2006.
I think that everybody's aware of it because by then I think it was all common knowledge that was coming up over and over again everywhere. Because
what about this then? You had seen the advice which said that, in summary, Mr. Jenkins was a witness upon whom reliance could not be placed. He was a tainted witness, yes?
Yes.
You knew that he had given witness statements in cases before the 1st of January 2010, didn't you?
Yes. Yes, I did.
Did you put those two pieces of knowledge together?
I didn't consider it. I wasn't part of any of this. That wasn't my role. As I said to you, I was not part of the mediation. All this advice is not taken over.
This isn't about the mediation. This is about the Cartwright King review of potentially unsafe convictions.
Yeah. But as I said, this is a matter which the General Counsel and the head of legal are seeking directly from Cartwright King and taking their advice on. I don't think I was privy to any of it, and as to what and what not they were deciding. It was a matter for these decision makers.
Was there a belief in the post office of which you were aware that very great difficulties might be caused for the post office if there was an examination of the existence of bugs before the 1st of January 2010 and that the disclosure that the post office had given or not given about such bugs?
I wasn't part of any of this. This is outside of my role, outside of my remit. It was something that if you like, the senior members of the legal team were dealing with. I don't think I knew anything about any of this.
Can we look, please, at poll 0014 8714? And can we start by looking at page 4, please? And if we scroll down, please. It's an email. Sorry, can we just look a bit below? And again. No, that's the end. Okay, just up then to the email, please. An email from Mr. Parsons in July 2014 to you and others. My thoughts, this is on the instruction of a new expert. A key question appears to be whether ICL, in this context, that's Imperial College London, yes?
Yes.
Look at old Horizon as well as Horizon Online. My guess is that the Post Office won't be looking to prosecute any old Horizon cases, so we can focus on Horizon Online. Martin, Jarnail. As to access to second site material, I can't see in principle any issue with this. Material going to second site has been largely vetted already. However, Martin, Jarnail, could you confirm whether an expert under criminal law has to disclose all material instructions or source material in their report? In the civil process, the general rule is that the expert must disclose to the court and the other side pretty much everything they've considered in forming their opinion. If this applies equally to criminal procedure, then Cartwright King and the Post Office may wish to vet material before sending it to Imperial College London. We may want to explore what Imperial College London intend to investigate under the fitness for purpose heading. This could be as simple as, does Horizon provide the necessary functionality? Or it could go wider to, does Horizon provide a good user experience? From handling IT disputes in the past, I know that determining the quality of user experience can be a very subjective question. That's difficult to answer. And if we scroll up, please. Mr. Smith advises, I would not advise the experts be instructed to look at the old Horizon system. You're in copy on this.
Yes.
If the experts were to consider the old system, depending on their findings, disclosure issues could arise in historic cases. Just stopping there, were you concerned at this point, mid-2014, that if the new experts, proposed experts, were to look at old Horizon, disclosure issues might arise?
No, all I was concerned with, the independency of it, that they get full access from the Post Office and for Fujitsu's to make sure that they carry out independent review of it. I mean, that's the whole point of the independency. I wasn't interested. I don't think I put my mind to as to whether they look at the old system or the new system. Obviously, the new system, because we want. I think the Post Office wanted to consider the investigation and prosecution side of things. I don't think I set my mind on it. I think it's Martin mentioned it because they're reviewing the cases and they are prosecuting them. I was completely hands off. I'm here to progress the report. Nothing more than that. What do you think Mr. Smith is referring to here? Disclosure issues in relation to historic cases? I think you need to ask Mr. Smith. I honestly don't know. We had a go at that earlier in the week, but I'm asking you. I don't know, because I know my from Jessica and Chris was, look, Jarnail, you need to progress this. I think Susan started it, and it's just taken a long, long time to get here. So all I was concerned with is getting ICL and getting the budgetary sorted out in line with the instructions from Chris and Jessica. I wasn't considering it to any more than that. He continues, in criminal law, instructions and material provided to an expert must be listed, etc. Cartwright King would not wish to vet information prior to sending it to Imperial College London. It would be counterproductive to withhold information. The experts may well refer to such attempts and missing information in the report. This would devalue the report and make it easier
for defendants to challenge, and then scroll up, please. You reply, I agree with Martin. The post office cannot be seen to, I think you mean cherry pick, to be cherry picking the information provided to the experts or withholding the information. Experts are independent, and the post office cannot be seen to be trying to influence the experts.
Yeah, well, there you go.
Was there a nervousness that there were bugs that were operative in Horizon before the 1st of January 2010?
Certainly not. It's just taken such a long time for them to make a decision to get an expert in or find an expert, and it's just helping to progress it. And
was there a nervousness that if we get the experts to look back too far, they may discover bugs that will cause us disclosure problems?
Certainly not on my part, no.
And therefore, the post office shouldn't look too hard at that question now, unless they needed to do so in order to prosecute new claims or prosecute in the criminal courts new cases based on old Horizon.
No.
If we go up, please. And then keep going. To page 1. Sorry, it's the email at the foot of the page. You say, let's not lose sight of the fact that Cartwright King are specialist criminal lawyers. They're in a far better position to advise the post office with regard to experts' instruction. They're acting in the best interest of their clients, i.e. the post office. The way in which the report is being commissioned preserves the integrity and independence of the experts. It's intended to instruct the expert to prepare the report in accordance with the scope. With the proviso, they immediately notify Cartwright King of anything which may cause concern. And then scrolling down, please. Paragraph 8, let's not lose sight of the fact that it's in the post office's wider interest to get the report and Fujitsu, which gives the Horizon a clean bill of health. In paragraph 6, you said if there are any concerns, in paragraph, if we scroll up a little bit further. Yeah, paragraph 2, you say, it's intended to instruct the expert to prepare the report in accordance with the scope, with the proviso that they immediately notify Cartwright King of anything which may cause the post office concern. It will enable the process to be terminated without full costs being incurred. Was it your intention that if the expert discovered something of concern about Horizon, their appointment would be terminated?
No. I think there was a concern about cost and scope. And
this isn't about scope.
That's my understanding of it. I think there was some discussions, and I'm trying to recap or summarise what's going on. No, that wasn't. It was just basically the independency of it, and that the post office is kept away from it, and it's a matter of Cartwright King dealing directly with the experts.
Paragraph 2 says that if the expert finds anything which may cause the post office concern, they're to tell the prosecution solicitors, which will enable the process to be terminated.
Well, that's wrong. That's not what the intention was. Obviously,
tell us in which way the words need to be rearranged in order to give them a different meaning.
I don't know what it in that respect. Well, I'm trying to get the independency of it, poll away from it, and you've got independency of the third party dealing with them directly rather than poll. That's all.
Your concern was that if the expert told the post office something uncomfortable, they'd either be told to stop looking or their appointment would be terminated.
No, absolutely not. I don't think that was the intention.
What does that paragraph mean then?
I don't know what it means, but it was that was.
You wrote it.
Well, certainly I did, but that's not what it means. Is keep the independency of it, keep it away from the post office, and the integrity of the report and the independency. And if there is something they need to go to Cartwright King to progress it. No more than that.
If that's what it meant, why didn't it use just the words that you have described?
I wish I had.
Yes, but why didn't you?
I don't know. I can't recall. It's a while ago.
Is the true answer to that because the words that you used disclosed your true approach at the time, namely, the post office does not wish to discover anything wrong with Horizon?
No.
If anyone starts to find things wrong with Horizon, we'll terminate their appointment.
No.
You tell us in your witness statement, it's paragraphs 94 onwards. Which is on page 34. Whilst that's being turned up, sir, I should have told you at the outset that none of the call participants wish to ask questions of Mr. Singh. So I've been given some new information. Update on that. But one call participant has asked to ask some questions, which I can't imagine will take that long. And therefore, I propose to go straight through, and then we'll finish well before 3:30.
Right. Fine. And obviously, I will hold everyone to that, not least in the interest of the transcriber.
Yes, thank you, sir. From paragraph 94 onwards, you deal with the issue of the appointment of an expert. In 94, you refer to the documents that you have considered. And in 95, you say, I recall I had some involvement in seeking a new expert to opine on the integrity of Horizon. You didn't draft a document, but you were asked by Susan Crashen or Hugh Flemington to seek board approval. That was something you'd done before. And then a little further on, in 96, you say, I can see there's reference to arrangements for a meeting. You can't recall attending. It took a long time to get new experts. I see I was involved in seeking approval from Chris Oyard, General Counsel. 97, I've been asked to what extent, if at all, did I agree with Martin Smith's advice not to investigate Horizon cases to concerns that disclosure issues could arise in historic cases. And you say, I recall I was primarily concerned that the experts would have access to all the information they felt they needed. That was the reason for my email. And 98, my recollection is that the experts were being instructed in respect of the integrity of the current system. Can we look, please, at poll 0014 7068? And page 2 to start with, please. And an email from you to Mr. Flemington, if we scroll down. Sorry, scroll up a little bit so we can see the top bit. From you to Mr. Flemington, in December 13, we've identified 2 experts as the ideal candidates for the role. I think they will provide a validated opinion as to the present integrity of the system, so as to lay to rest the present concerns relating to the integrity of Horizon Online. Why did you say that the potential expert would speak to the present integrity of the system so as to lay to rest the present concerns?
I don't know, sir.
In framing it that way, do you accept that you were effectively foreshadowing the opinion?
No, I don't.
Setting out what you were looking for?
I wasn't looking at anything. I wish I knew to explain that to you very clearly. Certainly, all I was concerned with is try and get an expert, because it's just taken a long time to get anything off the ground. I mean, in the end of the day, I think we just basically gave up because the post office they wanted it, they didn't want it. So those are the matters you really need to have Mr. Flemington or Susan Crichton or Chris here, because I can't help you with that. All I've done is they asked me to get the expert independency expert to the integrity of the system. That's all I'm doing. I'm not doing anything more than that. Maybe it is wrong here, but that's not what it is. What you're suggesting is not true.
Did you disclose to the putative new experts the expert evidence that had been given by Mr. Jenkins previously?
So it didn't even get that far. I mean, it didn't even get very far. I mean, it's stop start sort of system. Post office wanted it, they didn't want it, and I'm just going by whatever I've been told by Hugh Flemington to do or not to do. It's nothing more than that.
Can I look at it from a different angle then? Can we look at poll 0013 9879?
Yes. Oh.
Do you see this as an attendance note of a meeting in Scotland, firstly with BTO solicitors, and then secondly with the Procurator Fiscal in Edinburgh?
Yes.
Were you present at this?
I was present on the 5th, not the 4th.
You were present on the 5th, but not the 4th?
Yeah, I don't think I was. I think they had Cartwright King and BTO probably met the day before or something. I think.
Can we go then to page 3, please?
Yeah, there we go.
This is the record of that meeting on the 5th.
Yeah.
And we can see that you're present.
Yes.
Yes, we can see who else is present. 2 from Cartwright King, 2 from BTO, 1 from Post Office U, and 2 from the Procurator Fiscal.
Yes.
Was this meeting, looking at it broadly, in response to the Procurator Fiscal's initial view that all post office cases should be terminated because they couldn't prove Horizon was wholly reliable?
Yes. Yep.
Can we go forward to paragraph 12 of the meeting note, please? Thank you. And the second sentence, it says, Simon Clark provided the meeting with a broad overview of the Horizon Online difficulties, absence any direct or indirect reference to the role of Gareth Jenkins or Fujitsu. Can you see that?
Yes.
And then paragraph 13 over the page, please. Simon Clark then outlined the proposed instruction of independent expert witnesses and the scope and depth of these experts' reports. PM, I've forgotten who that is. If we scroll back. Paul Meal, thank you.
Oh, policy.
Or Mealy, from the Procurator Fiscal. Then back to 13, please. Mr. Mealy indicated surprise at the seriousness, at the depth and depth to which the Post Office was prepared to go in dealing with the Horizon Online issues, and was clearly appreciative of the approach being taken. He suggested the matters outlined went a long way to meeting the Procurator Fiscal's concerns as to both present and future prosecutions. At this meeting, why did you not disclose to the Procurator Fiscal and to BTO that there had been a problem with Gareth Jenkins' evidence in past prosecutions?
I was asked by Susan to go along with it. I don't go along with for the meeting, but I didn't know the ins and outs as to how the review was going, or I wasn't privy to any information further than that. I mean, Simon Clark is senior barrister, and I went along, and I think I don't think I said very much. I just introduced them to them who they were, and just left him to explain everything.
So if we go back to paragraph 12, please. You'll see in the brackets there.
Yeah, I can see that.
A note is made that
but
Horizon Online difficulties were referred to absent any direct or indirect reference to Gareth Jenkins or Fujitsu. Was there a desire to keep that secret?
Not on my part. I don't know anything about this. You probably need to ask Simon when he comes to talk to you. But
Did you tell the Procurator Fiscal why the Post Office needed to instruct new experts? I.e., what was wrong with the old one?
As I said, I don't think I said very much here, apart from the introductions.
Did anyone say what was wrong with the old expert and why new experts needed to be instructed?
I can't recall, but it was basically Simon and Martin, I think. They were leading it.
Did anyone disclose the Simon Clark advices, the whole string of them?
I don't know. I don't recall, but I mean, they might have done. They had a meeting prior to me going there. I just went along because Susan asked me to, attend. I mean, and that's what I basically did. I didn't take any part. I wasn't privy to much information. I mean, if they asked any point, a Post Office view, I don't know what more I could have given. But it certainly, I don't even know what discussions Susan and Cartwright King had, or BTO had, and I was just attendee, observer. I mean, I don't know any more than that. I can't really help you with that anymore.
To your knowledge, did anyone draw to the Post Office Board's attention the Simon Clark advice of the 15th of July 2013 concerning Mr. Jenkins' reliability?
I had no dealing with the board, very little dealing, and I don't think I had any dealing with the board. I don't think I even met any board members. I mean, obviously Chris used to report, the senior legal teams.
Was there any discussion between you?
No.
That this is so serious?
It is serious, I agree.
The Post Office Board need to know about this.
As I said, I'm a criminal lawyer. My job is, as you described it, as a postbox, which I agree with. I mean, and that's all it is. But I wasn't privy to any of it. It's to high-level discussions as to what was disclosed, who to disclose to, who knew what, when. I have no idea. I can honestly say that. I'm on oath, and I'm telling you that. I'm staggered as to hear what you're telling me.
Was it thought of as a dirty secret?
Not on my part. I didn't know any dirty secrets.
And it shouldn't be revealed to the board, nor should it be revealed to the Scots?
Well, I think you've been talking to senior members of the team. I mean, they're the one privy to it. I think you need to maybe call them in and discuss that with them again, because certainly I can't help you with that.
Many of the prosecutions had occurred on your watch, hadn't they? That can come down, thank you.
How do you mean?
Well, whilst you had been a criminal lawyer at Royal Mail Group and then at the Post Office, a number of sub-postmasters have been prosecuted.
I dealt with my cases, but as I said to you, the head of criminal law, Rob Wilson, wasn't very good at declaring information, and I think he was the contact within the greater business. And as I said to you, apart from him, I don't know any members of the board. I don't know anybody within the business that much, because I didn't have that much contact.
In all of your time, was there no discussion Aren't the board interested in this? Or why haven't I been asked to contribute towards a board paper which sets out what's gone on here?
What, you mean in the Royal Mail Group?
Yes.
No, there was Rob Wilson. I said he was the contact within the business. I don't know who the board members were.
I'm not asking you whether you knew who the board members were. I'm asking you as a person...
If I don't know them, I can't have a discussion with them, can I? But no,
I wasn't asking you whether you had a discussion. I was asking you, were you not querulous? Were you not wondering to yourself, hold on, some things have been discovered here that have gone badly wrong. Does our board know about this? Or why haven't I been asked to contribute to a board paper or some briefing of some very senior people who want to know what's gone on here?
I wasn't asked, and I don't think I thought very much about it because I didn't know much about any of it, what was going on. I mean, I basically was a criminal lawyer dealing with the cases as then when they were allocated to me, most of it with direction as to what to do on them. No more than that.
Mr. Singh, on that note, they're all the questions I've got to ask you. Thank you. So it's, I think, the Hudgell's team, and up to 10 minutes, sir.
Right, you.
Good afternoon, Mr. Singh. My name's Angela Patrick, and I represent, together with Tim Maloney KC, a number of sub-postmasters who were prosecuted and have since had their convictions quashed, including Mrs. Hamilton, who I'm sure you can see sitting next to me today.
Yeah.
We only want to ask you about one issue, and it's about the handling of criminal prosecutions which were live at the time of the publication of the Second Sight review, the first interim report. Did you see the evidence of Mr. Martin Smith yesterday?
I heard, yes.
Yeah. And you remember we were talking then yesterday in questions to him about how in July 2013, immediately before the publication of the Second Sight report, and at a time when it was known to the Post Office that it would identify at least some bugs in Horizon, do you remember then that there was a case of Samra that was due to come on for a hearing?
Yes.
And do you remember agreeing with Mr. Smith and Mr. Clark that they would contact Gareth Jenkins before that hearing came on?
I don't think no.
If Mr. Clark had made a note of your agreement that they should do that, a contemporaneous note, would you accept it was likely to be correct?
All I can remember about that case was dealt with by the head of legal, Hugh Flemington. I had very, very little to do with it because I don't know the ins and outs of it as to the reason for it, but I can't really help you or assist you more than that.
I don't think Ms. Patrick is asking you about the case. She's just using that as a point of reference to ask you about a discussion you may have had.
I can't recall, to be honest. I don't know.
I'm very grateful to the chair, but I think it's even simpler.
Okay.
You knew Mr. Clark and you'd worked with him for a long time.
Yes, I did, yes.
If he made an attendance note at the time that said you agreed to something that he and Mr. Smith had suggested, would you expect that to be correct?
Of course, yes.
Thank you. So, 1st of July, Samra's coming on for trial. Do you recall agreeing that there would be an application for a public interest immunity certificate to prevent disclosure to the defence of the fact that the Second Sight report was to be presented to Parliament and that that report contained references to bugs in Horizon?
That was a matter for my line manager, Hugh Flemington, who made the decision. I didn't make any decisions.
Again, if Mr. Clark had made a note of your agreement that they, Mr. Clark and Mr. Smith, should make just such an application, would you accept that it would be likely to be correct?
Well, it's correct in the sense that I didn't make the decision. He advised the Post Office, the decision maker, the head of legal, Hugh Flemington, did that. But I mean, I wasn't privy to the advice.
Can we just look at the note? It may be helpful.
Okay.
It's Paul 00172 804. It may help your memory, Mr. Singh. And we're looking at page 7, paragraph 16, please. And this is Mr. Clark writing. In this case, I took the view that such an approach, an application for public interest immunity, to the problem might be appropriate. Accordingly, Martin Smith and I, in conjunction with Jarnail Singh, decided that the best way forward was to, 1, seek a ruling, i.e. the grant of a PII, public interest immunity, certificate, from the trial judge that we need not disclose to the defence the fact that the second sight report was to be presented to Parliament today and that the report contained references to the existence of bugs in Horizon, both past and present, and 2, to adjourn the trial, and so on. You see there, Mr. Clark has made a note that the decision is made with him, Mr. Smith, and in conjunction with Jarnail Singh. Do you see that there, Mr. Singh?
Yes, I do. It's very clear. Yes.
There's no reference to Hugh Flemington, is there?
Well, I'm not the decision maker. I don't know how it came about. Certainly, Hugh Flemington is the decision maker. I don't know how that fits into it. I don't even know what the certificate is because I'm not that well knowledgeable about these things. And obviously, the Post Office and the decision maker has decided to instruct Mr. Clark to make such an application.
You've accepted that you knew Mr. Clark. If he made a note at the time, it's likely that that would be done correctly.
Yeah, it wasn't.
Just to explore your recollection, might be able to help your memory, but can you recall, looking at this, what the basis for the application for public interest immunity was to be?
I don't recall. I don't know.
And you're at this point a very experienced solicitor. An application for public interest immunity in criminal proceedings is a very serious step, isn't it?
It probably is, but my understanding was limited. It's something that senior counsel is leading on instructions from the Post Office senior legal team, like Hugh Flemington and probably, the General Counsel.
Now, if I suggested to you that the basis for such an application is very limited, and it must engage very serious matters of public interest in order to withhold material from the defence and from the public eye, serious things such as national security, would you accept that's a rough explanation of what a public interest immunity application might be about?
But certainly, yes. But I mean, I wasn't privy to the case. It's not one of my cases I'm dealing with. It's something the decision has been made, and Mr. Clark and Mr. Smith are dealing with it. It more or less, I don't know what my involvement in it was because I don't know any details as to the application.
Well, we can talk to Mr. Clark about his note, and he here records that the decision was made in conjunction with you. So can we just look at the reasons for the application, just to see if it prompts your memory, Mr. Singh? If we could look at page 9 at paragraph 24, please. Thank you very much. And here we see Mr. Clark records his reasons. Finally, it's worth commenting on the reason behind my advice that we seek a PII, Public Interest Immunity Certificate, in this case. Paul were, rightly in my opinion, very concerned at the potential adverse publicity which would inevitably be generated by the revelation of the existence of a draft second sight report into Horizon. To permit this information to enter the public domain at such an early stage would have been to encourage extremely unhealthy and likely virulent speculation as to the content of any report, most probably in the national press. Such speculation would have seriously damaged the reputation of Post Office and would have greatly undermined public confidence in both Post Office and Post Office systems. Our objective was to avoid such consequences. That objective we achieved. Our objective was to avoid such consequences. Was that a proper basis for an application for public interest immunity, Mr. Singh?
I've got no knowledge about these things. I'm probably like a article clerk sitting behind a senior counsel who's on top of his game. But that's a decision made by the Post Office on advice, and as a criminal lawyer, I've been advised to assist. But I don't know the ins and outs of this particular case because it's not something I advised on or dealt with.
Mr. Singh?
Yeah.
Mr. Singh, we have this note. We have Mr. Clark recording. It's a decision made in conjunction with you. Was this an example of you seeking to cover up things if you could?
I'm not seeking to cover up anything. I don't know the ins and outs of this. In all seriousness, this is a matter you need to discuss with Mr. Clark and the senior legal team. I am purely there on instruction, on whatever I've been asked by my line manager, Hugh Flemington, or whoever it is, Jessica or Hugh Flemington, to have an input in whatever they decide to do. I mean, I couldn't say, look, I disagree with that, I'm not going to do this. So I think...
Mr. Singh, can I stop you there for a moment?
Yeah.
At this point, 2013, you're the sole criminal specialist at Post Office, aren't you?
I'm a criminal lawyer, but I wouldn't say I'm a specialist or expert particularly.
Thank you. I don't have any more questions for you, Mr. Singh. Thank you very much.
Thank you, Ms. Patrick. That's it, Mr. Beer?
Yes, sir, it is.
Well, thank you for making 2 witness statements, Mr. Singh, and for making yourself available on 2 separate occasions to be questioned. I'm grateful to you for your participation in the inquiry.
Thank you, sir. Thank you.
So we'll adjourn now until Tuesday at 9:45, Mr. Beer?
Yes, that's right, sir.
Fine. All right, then.
Thank you very much, sir.